When the government, or even a private company, takes your land using eminent domain, the law promises you just compensation. But what about the thousands of dollars you spent on legal fees fighting for your fair share? For a group of North Dakotans facing off against a natural gas company, the answer could be tough luck. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Bob McNamara and Matt Liles. We'll discuss what just compensation really means, how the government lets private companies abuse eminent domain, and what IJ is doing to stop it. This is Beyond the Brief. So, Bob, how did this case start?
Sure. So this is an eminent domain case. And what happened is a natural gas pipeline company wanted to build a pipeline through McKenzie County, North Dakota, through some ranch land that has been in our clients' families for years. And this isn't your usual eminent domain dispute. You'll often see pipelines where people say, no, there shouldn't be a pipeline at all, or environmentalists saying you can't build this. This is North Dakota oil country. So there are already a lot of pipelines. These ranchers know how pipelines work. And they said to the company, sure, this is kind of the going rate. This is what other people pay for pipelines in this area. This is what it costs. And if you pay me what it costs and put it in a place that's convenient, that's fine. And the company said, well, actually, under federal law, we have the power of eminent domain, so we don't have to pay market price. Which is like, it's a crazy thing to say, because the whole idea of eminent domain is when the government takes your land, they have to pay you market price. And so our client, Len Hoffman, and his family kind of rallied the neighbors. They said, this isn't fair. If they can do this to us, they're going to do this to other property owners in this area. We need to stand up for ourselves. And they did, and they won. A judge ruled that actually evidence of market price can come into evidence, which is, kind of an obvious thing, but it took them years of litigation to get to. And that ended the dispute over the value of the land. But it cost them about $300,000 as a group to hire experts and pay for lawyers and litigate the case to that point. And under North Dakota law, a property owner who's condemned is supposed to be made whole. They're supposed to they don't have to foot the cost of their own condemnation, because the idea is they should be in the same position they would be if they hadn't been condemned. So the court awarded them their costs and fees, but then an appellate court said, well, actually, since this is a federal condemnation under the Natural Gas Act, Congress meant to sweep aside all of your state protections for property rights. And what the Natural Gas Act means is as long as they pay you enough that it doesn't actually violate the Constitution, state law doesn't matter, and you just lose all those protections for nothing. And that's kind of the genesis of the dispute.
So, Bob, this is very different from sort of the traditional IJ eminent domain case where we're representing property owners who don't want to give up their property. And so they're fighting the taking. Here, the taking has already occurred. The owners are okay with it. This is just about how much money they're getting paid for the property and making sure that they're made whole. How does this fit within kind of IJ's broader work in the eminent domain space?
Sure. So there are two aspects to eminent domain. There's the fact that eminent domain has to be for public use, which we fight about and continue to fight about. But there is also the principle that the government, or in this case, the private company using the government's power, has to pay for what it takes. And this particularly matters because this is about whether people can get into court in the first place. And this is something IJ fights about in a lot of areas, like forfeiture and eminent domain. If the government comes to you and says, hey, give us your property, and you say, wait a minute, that's not fair, I want to defend myself, you have to be able to pay to defend yourself. And that has to be, if you're right, you have to be made whole for that. And so the basic idea that we have to make it affordable for people to defend their property when they're not lucky enough to be represented by IJ is core to the idea that people have to be able to defend their property in the first place. If IJ successfully establishes, say, a Supreme Court rule that says you can sue the government to make them pay you when they take your property, that only matters if you can actually get a lawyer to sue the government to pay you when they take your property. And so this is about the ability to defend your rights, not just the underlying substantive rules.
Matt, how is it that a natural gas company can use eminent domain? Isn't that a power that belongs to the government?
It is a power that belongs to the government. In this case, there's a federal statute from the 1930s called the Natural Gas Act, where Congress gave natural gas pipeline companies the power to take land when they are building interstate pipelines. And so the federal government has essentially delegated its eminent domain power to pipeline companies or natural gas pipeline companies. And there are companies that don't have that power. So oil companies in North Dakota, they can't use eminent domain. And so their behavior when they treat or when they negotiate with landowners is drastically different. They have to negotiate voluntarily with a landowner if they want to build a pipeline on their land. If you're a natural gas company and you know you can just take the land anyway, you're going to come in and you have an incentive to build the pipeline as cheaply as possible. And so a lot of times you end up just pushing the landowners around. And this case is important because it's about the ability of landowners to get a fair price and not have to pay out of pocket for the costs of fighting for that fair price.
And the fact that this is a private company actually really matters because eminent domain is supposed to be the government's power. The government isn't supposed to be able to willy-nilly just give people the power of eminent domain. And the courts have really drifted away from that principle in a lot of ways over the years. And what actually happened here is, the Natural Gas Act doesn't have all that many words in it about eminent domain. It doesn't say anything about just compensation. And what the court said in this case is, well, if Congress wanted to, it has the power to sweep aside state protections for property rights when it's taking land. And so we should just assume it did the same thing here when it delegated this power. And that's not how you're supposed to read delegations of eminent domain, right? They're disfavored. You're not supposed to do them. And we've kind of gotten to this point where the courts are so used to the power of eminent domain being given to private entities that we just assume that, well, of course, a private entity is just like the United States Congress. And it's not. And trying to revitalize that principle and pull back on some of this expansive delegation of eminent domain is another reason this case is important.
Are there any other sort of common contexts in which the government has delegated eminent domain to private companies, or is it really mostly oil pipeline? Like, are there other situations where that's a common occurrence?
So the classic example is railroads. And, the middle of the 19th century is when the United States had the railroad boom. And so a lot of the early delegation cases and eminent domain cases are about railroads. And you actually see a lot of state protections for property rights that are written into state constitutions come about at the same time as a direct reaction to these delegated railroads that are causing massive damage and outraging people. So that's sort of the big historical example is the common carrier railroad. But the basic idea that there can be common carriers that are sort of open to the public, even if they're operated by private companies, does have some historic footing. But it's something that has become so commonplace in the modern era that it's treated as easy and obvious when, in fact, historically it was exceptional and narrow, if that makes sense.
Just as a sort of, because you mentioned railroads, and I've been picturing these pipelines as being like underground. Are they underground? Are they above ground? What do they look like?
The ones on our client's property are mostly underground. Is that right?
Yeah, they're underground, but they're disruptive. So to build the pipeline, you have to, dig a giant trench through people's property.
Sure.
It disrupts the land. And you can actually see on our client's ranch, there's one pipeline where just the grass doesn't grow there anymore. That hillside just doesn't look like the other hillsides. And the companies have to maintain the pipeline. Our first tour of our client's ranch, I remember they were driving us around in their ATVs and it's beautiful land, just absolutely gorgeous. And they're driving us around. They're so proud of their land. And there's this guy out there kind of in his own ATV. And he drove up to us on our client's land and said, "Oh, hey, are you guys pipeline or are you owners?" Which, just imagine someone showing up at your house and be like, "So do you live here, or are you just one of the dudes who's allowed to walk around?" So it is genuinely invasive in a striking way. And again, our clients they're pro-development, pro-economic growth guys. They want pipelines there. But the pipelines cause real damage and real disruption, and they want fair compensation. They don't want companies to run roughshod over them or their neighbors.
So the Eighth Circuit's decision in this case, where they said, just compensation does not include payment for, paying for an attorney. How common is that sort of a holding? Is it an outlier in the federal circuits, or is it in line with what some other circuits have done in this space?
It's a massive outlier. So this is really only an issue because of the decision in this case. For over 40 years, every federal court to look at either this statute or a statute like it has said, well, the statute doesn't say anything about just compensation. This is a dispute between private parties, so whatever extra protections you have in state law, control. We should look to state law to figure out how much you're owed. And that has real consequences, not just for things like fees, but sometimes for what you can get compensated for at all. If you have a contract to sell the wood from the trees on your land, does that come in as part of the value of the property? Some states will authorize that in places where the federal government won't. States have all kinds of different, sometimes innovative protections for property owners to make sure they're actually getting a fair shake when they're condemned. And if the Eighth Circuit's right, courts should have been casting those aside for 40 years, and instead courts have every single time been enforcing them in the property owner's favor.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So what happened in this case? What led the Eighth Circuit to just throw away 40 years of precedent and say we're going to do our own thing?
You know, the Eighth Circuit said everybody else has got it wrong. It kind of, to its credit, it didn't try to hide the ball. It said, look, yes, there are all of these other cases. We think from first principles, when there's a delegation of eminent domain, that necessarily means it's the full power of Congress to sweep aside any state rules about compensation, which is, again, this expansive way of assuming that if there's any delegation, it must be a delegation that eliminates state rules, even though state rules for compensation and state rules for property are what drove eminent domain in this country for the first 100 years of its existence. And so I think it's an odd assumption based on statutory silence, but it is, it's a forthright opinion. It says everybody else is doing this wrong, and that's part of what got IJ involved, because everybody else has been doing this wrong for 40 years is kind of a signal.
It's
the
kind of
Supreme
noteworthy.
Court might want to get involved.
So we have other cases that involve sort of this idea of paying attorney's fees. And in those cases, other federal courts have said, no, you don't get attorney's fees. And it's been in mostly the civil forfeiture context. So how is that kind of different from what's going on here?
So it's actually very closely related. There are different statutory schemes in both cases. And, we're not saying the Constitution requires fees, but there are these statutes, there are these other sources of law that say you get fees. And what's going on in the forfeiture context is there's a statute that says if the government tries to forfeit your property and you prevail, it has to pay for your cost of litigating. Because otherwise, the government could seize $20,000 from you, litigate until you had spent $20,000, and then just go home, and you're at zero no matter what.
Right.
But what the government does in these cases is it takes your $20,000, it litigates, and then it asks the court to dismiss the case without prejudice. Like, well, we're going to give the $20,000 back, but we might come back later. And of course, they're not going to come back later. They've lost the case. Everyone knows they're not coming back later. But they're trying to escape the legal obligation that exists to make it possible for people to defend themselves. And it's the same thing happening here, where the private company is trying to escape the legal obligation that exists to make it possible for people to defend themselves. And so in both of those contexts, IJ is defending people's ability to fight for their property without every time needing to hope that they're lucky enough to engage IJ. Like, private citizens are supposed to be able to do this on their own. The rules are set up so that private citizens can do this on their own, and those rules just are not getting enforced. And that's where IJ comes in.
And just compensation is a really important limitation on the government's eminent domain power, and in this case, private companies. When IJ does eminent domain work, it's typically about public use issues, but the Supreme Court has said, the just compensation requirement, you're supposed to be put in the same exact position financially as a landowner as you were before your land got taken from you. And if you aren't entitled to attorney's fees and the costs of trying to get a fair share of your land, then you're kind of put in a catch-22 as a property owner. Either you take a lowball offer from a natural gas company in this case, or you decide to fight and try to get the fair market value, but you have to pay for it. And so the fact that you have to pay for your own defense, even if you end up getting a fair market value, it kind of shatters the guarantee of just compensation and makes it a much less meaningful right.
Yeah, it seems like it tips the scales in negotiations in favor of the government or in favor of the company that's trying to take your land, right? Because it's basically saying, like, you either have to foot all this money up front to fight back and to actually engage in some sort of negotiation, or they can just kind of give you any number and you're sort of forced to take that number.
That's exactly right. The choice is, I'm going to give you $300,000 less than your land is worth. I'm just going to pocket that $300,000 for myself. And if you don't like it, you can pay that guy $300,000 to fight me for it. But there's no universe where you keep that $300,000.
Sure.
It's just me or your lawyer, and you can choose which of us has it at the end. It just can't be you.
Well, and it sounds like that's one of the issues kind of rolling along in the background of this case is the fact that the natural gas company came in and lowballed these property owners because they're, for property owners, pretty sophisticated in understanding what a pipeline costs. As you mentioned, Bob, this is something they've dealt with before. They know what the fair market value is, and the pipeline company probably does too. And then they came in and pulled this lowball and now are trying to kind of evade accountability for that. How common is this in eminent domain where either the government or the private party who's been delegated that eminent domain power is coming in and lowballing property owners?
Oh, we see it again and again and again. When you give someone the power of eminent domain, they act like they have unlimited power. And the common conversation homeowners and landowners have with anyone with the power of eminent domain is the land agent comes in and says, this is our offer. If you don't take this offer, we're going to go to court and you're going to like it a lot less. And it's just a striking difference. And we see it again and again in these situations where the power of eminent domain is taken away, that suddenly people without the power of eminent domain start treating property owners like they're human beings. Like perhaps you need to negotiate with them and make them happy. And it's perfectly possible to do, but vesting someone with the power of eminent domain makes them think they don't have to do that anymore. And you see people try to run roughshod over property owners, and all too often you see the property owners actually get run over, either because they don't know they have legal rights, they don't have the financial wherewithal to hire someone to defend those rights, but it makes a massive, massive difference in the outcomes, and it is one of the many reasons that the power of eminent domain needs to be strictly limited.
We had a case in 2019, I think, involving a pipeline in Pennsylvania, and that was also, the issue there was also a compensation issue. How does that case interact with this case?
So it's not the same issue, but it definitely rhymes in that both of them are examples of just the abuses of this delegated power. Where Congress has authorized natural gas companies to condemn property, and to the extent they're common carriers, they're allowed to do that in certain circumstances. But in that case, it was about quick take. There's a federal statute that says if you really need the land, you can just go in and grab the land, and it's your land on day one, and we'll figure out compensation issues later. Congress hasn't authorized natural gas companies to use that statute, but what courts have been saying is, well, you're going to end up with the land at the end of the day anyway. It doesn't matter that Congress didn't tell you you can take it immediately. And so companies are, to this day, being allowed to go into court, grab the land at the outset, and then delay the adjudication of just compensation for years after that, years before property owners get what they're due. And it is this same idea that we're looking at the delegation of the power of eminent domain, which is supposed to be unusual and rare and strictly limited. And courts look at it and they say, well, you can probably get away with whatever you want. And that just sort of blasé attitude is, I think, what's infecting a lot of this. So the issues in those two cases are different, but I think the source of the abuse and just the absence of skepticism of these delegations is what's driving both outcomes.
You had a case at the Supreme Court recently about a rancher whose land was being taken. Can you talk about that a little bit and, whether that has anything to do with this case here?
Sure. IJ does have a growing practice in ranch land, I guess, but that was DeVillier v. Texas, where we represented Richie DeVillier and his family, who were suing to get just compensation for the state of Texas's deliberate flooding of their land. And Texas said there, we can't be sued at all. You're just not allowed to sue us to enforce your Fifth Amendment right to just compensation. We took that up to the United States Supreme Court, which unanimously said, yes, they can sue Texas. Texas, by the end, just conceded that they were allowed to sue Texas. But that's another story. And it is similar in that it is about the second obligation government has. The government's first obligation with eminent domain is to only use it for public uses. But when there is a public use, the compensation matters because it's always going to be more politically popular to do things cheaply, to do them on the backs of individual landowners, because an individual landowner only has one vote. Everybody else in the community who doesn't have to pay for the thing has more votes. And so part of what the Constitution recognizes in the just compensation requirement is, sure, the government has the power of eminent domain, but it can't be allowed to abuse the power of eminent domain to force one person to bear costs that really everybody should be bearing together. You can't single out Richie and say, your ranch is a lake. You can't single out Len Hoffman in North Dakota and say, your ranch is hosting all the pipelines. You have to pay just compensation. And no one likes to pay money. Governments don't like to pay money. Natural gas companies don't like to pay money. And so it's important to actually enforce those obligations and to try to enforce those obligations as a public interest organization in a context where it wouldn't necessarily make financial sense for the landowner to spend all of this money to establish a rule that, you know, they can't afford to establish.
How did IJ come to find out about this case? Because this is not a case that we've been litigating from the get-go. This is a case that we stepped in on, I think, after the Eighth Circuit issued its decision. Did the property owners reach out to us? Was this a case of IJ attorneys meticulously reading every Eighth Circuit decision, like I know some of us are wont to do?
This is really a situation where IJ's longstanding expertise pays off. Derek Broughton, the lawyer who represented the property owners in the trial court and on appeal, is a longstanding property rights advocate in North Dakota. We have known him for years, and I've known he was litigating this case for quite a long time. I talked to him after the oral argument. We knew this was probably coming down. And at the oral argument, the judges on the panel seemed very skeptical of Derek's argument, even though Derek's argument was the one that had been accepted by every federal court for 40 years. And so it sort of seemed to us that like, this might be going south. This might be in a situation where there's a circuit split, and it's certainly in a situation where it won't make financial sense for these property owners who are already out $300,000 to foot the bill for a cert petition that is mostly about other people's rights. And to the clients' enormous credit, they fully understand and have understood really for this entire case that what they're litigating about is not so much themselves, it's their neighbors, it's the next pipeline, it's whether you can do this to someone else. And so IJ offered to step in. We flew out, we saw the ranches and sort of talked about the goals. And the goal that they've had for this entire case is the goal in taking the case to the Supreme Court, which is making sure that this doesn't happen to other people and that these important protections for property rights don't just get swept aside by private pipeline companies.
When we talk about eminent domain, the thing that most commonly comes to mind is the Kelo case. And so, assuming the Supreme Court takes this case, we win, how does that bring us closer, or does it, to overturning Kelo?
Well, if the Supreme Court takes this case and we do win, then, we'll be stamping out another form of eminent domain abuse. And Kelo had to do primarily with public use issues, whether the government has the power to take purely for private economic development. This case is a little more about just compensation and, the ability of landowners to defend themselves. So, in some sense, they're kind of different forms of eminent domain abuse.
But they are both, property rights questions, and I think it's important that we be able to walk and chew gum at the same time. We have other public use cases. We're continuing to litigate them in courts across the country. But public use is not the only property rights question, and we know this is a court that is interested in property rights, and it's important to kind of maintain IJ's stance as an organization that brings interesting property rights issues to the court. And over time, maintaining that momentum, I certainly hope, leads us to get a Kelo question in front of them. But the Kelo question isn't the only thing that we can push, and it's not the only thing we will push.
And, part of the reason that this case is important, as I understand it, is, because in the aftermath of Kelo, we at IJ were so successful in pushing state legislatures to reform their rules about eminent domain. And I'm sure some states reformed their rules about just compensation. And now you have this Eighth Circuit decision that comes in and says, well, we don't have to look at all of these wonderful, robust protections in state law. In that sense, it's kind of a furtherance of the mission that we've been taking on post-Kelo.
No, I think that's exactly right. And I think it is something you see historically every time eminent domain becomes a salient issue, whether it's the railroads in the 19th century or the Kelo decision. People say, whoa, 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 this seems super unfair. We can't do this. And the response to that is a backlash to limit the power of eminent domain and to make sure that people are fairly compensated when eminent domain is actually necessary. And really what the Eighth Circuit's decision here threatens to do is to sweep a lot of state protections aside when those are the protections that when people are paying attention, everybody seems to think are the most important.
Well, thanks so much, guys, for coming in and talking with us about this today.
Thanks for having us.
Yep, thanks.
And thanks to all of you for listening. If you'd like to get more of our videos, you can like or subscribe to this channel. And if you'd like to support this case and our other work, you can join us with just $5 a month at ij.org/monthly. Thanks so much.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.